Now, hold on just a second. Mr. McCoy, what is the problem? Have a seat. I'm trying to have hearings. You talk to me, I'll call you up in just a little while. I don't care who you're talking to. You're bothering me right now. Y'all sit down and be quiet.
And right out of the gate, you can feel the tension. When a judge starts the day already sounding exhausted, that's your first clue this isn't going to be smooth. Representing yourself is absolutely a constitutional right, but it also means you own every mistake. No safety net, no one to blame. Question for you, if your freedom was on the line, would you really gamble on DIY lawyering?
No, just wait. Mr. McCoy. This is State of Florida versus Devontae McCoy, case number 24 CF 2543 and 2544. Mr. McCoy, as representing yourself, Mr. McCoy, do you wish to continue to represent yourself?
Yes, sir.
You know, at any point in time, you can ask for an attorney to represent yourself or to represent you, and one can be appointed to represent you. Is that correct?
Sir.
Okay.
Yes, sir.
All right. What are we set for today?
I believe it was set for a motion, but I had contacted the Sovcit CEO. They never replied, so I'm still waiting on my videos to come in. He said he will be sending them to me. So
They are going to send them to you?
yes.
Do you want a pretrial set on this, or do you want to set it for a motion hearing?
Probably a motion here.
I'm going to set it for the April motion. That'll give you sufficient time. April 8th. No, that's April 17th at 1:30.
Yes, sir. Do you know who's the state attorney in my case?
Who's the state attorney?
Technically Mr. White, but for now, I don't.
Your guess is as good as mine.
Because Miss McAfee just McAfee.
She's in another division now.
She just accepted my motion like yesterday, the day before. I figured she would have let me know that then.
I'm sorry, I can understand you.
I said she just accepted my motion like yesterday or the day before, trying to figure out why did she take it and not let me know that? Like,
I got no idea.
because I keep my case in a maze. Like, I don't even know who to file to. Like, I'm trying to figure out what's going on.
Welcome to my world.
Notice the confusion here. He doesn't even know who the prosecuting attorney is. That's not just awkward, it's a strategic disadvantage. In criminal court, knowing your opposing counsel matters. Communication channels matter, procedure matters. The judge's "welcome to my world" line, that's courtroom code for this isn't chaos, this is how the system works. But when you don't understand the system, it feels like a maze.
Yeah, been in it for a little minute. So
All right.
I go, but
We'll set it for April 17th at 9 o'clock. And Mr. Sullivan, he can contact, if he's representing himself, contact your office or contact Mr. Sullivan, okay?
you said Mr. White.
Mr. Sullivan is the supervising attorney, so that's who you want to talk to right now. Not today. He's got a bunch more to do, but that's right now.
Mr. McCoy.
Mr. McCoy, if you'll sign that notice. At 1:30. All right, Mr. Cruz, we'll call. Mr. McCoy, come on up. I'm gonna quick call your case. Mr. McCoy, you've made the decision to represent yourself. You understand at any point in time you'd like to have an attorney appointed to represent you. One could be appointed to represent you. Is that correct?
Yes, sir.
And we're set today. We got a notice of hearing. Second motion. Finish motion. I guess the second motion to compel.
Yes, sir.
All right. Go ahead, Mr. McCoy.
So, Your Honor, it's gonna be hard for me to move forward in my case without those or my videos or that evidence. So, that's the only reason I'm putting in my second motion to compel. And, I'm just saying without it, it's hard for me to, to have a defense, because that contains all my defense. So that's pretty much.
So at this point,
He's asking, I guess let me separate them out. He's got a motion to compel the cameras from the store.
which we've dealt with several times before.
I can't compel those. I mean, you haven't noticed those people. They're not law enforcement. They're not required to save those tapes. They're not required to send them in. I don't know if you've requested it from them individually.
I did, but they said it had to be done through y'all.
Yeah, well, you'd have to, if you were going to do that, you'd have to notice them. I think I've already told you.
I sent a subpoena in.
This is the turning point. He says the missing footage contains his entire defense. That's a huge claim. Legally speaking, though, courts don't magically retrieve evidence for defendants. A motion to compel only works if the party actually has control over the evidence. Private businesses, different story. If your whole defense depends on footage you never secured properly, that's not strategy, that's hope.
He answered women the owner talk, but they said they also need some law enforcement to come in to get the video.
That I can't direct law enforcement to do an investigation. That's not my job.
The attorney already went up there. She just didn't get it. She says she went up there anyway. The one that I had.
Miss McAfee. This is a separation of powers. I don't direct law enforcement to how they conduct their investigations. Now also I think there was some cam recorded. If I remember correctly, recorded
Body cam footage.
Yeah.
You have not received any of those?
No.
Okay. These discs there are 3 discs here. It's got, my understanding is cameras from FHP. They're written on here. FHP videos, and then cell phone extraction is the 3rd disc.
Okay, so what about the camera footage from Bay County? That's the ones I actually need.
Those are the only
FHP was only, they said they was only assisting Bay County. Bay County is the ones that the case is actually against because there
were no body cams from those officers. These are the only body cams that
they had body cameras on them. And I need that footage. And as far as the story video, that's where the crime scene took place at. I figured
that is a private, that's a private organization. I can't order them to release information or to get that. I don't have any jurisdiction over them.
Well,
I can't just.
According to Rule 37, Your Honor, you can't just not give me my videos, though. I'm pretty sure the officers got the videos because at the stores where the crime scene took place.
But I can't, if they say they don't have it, if they say they don't have it, I can't make them say something they don't have. So that motion is denied. Do you want some time to look at those?
This ain't gonna do me no good.
Do you want to go ahead and set it for trial?
I'm setting it in for a hearing, and I'm gonna put in my motion to dismiss. I'm gonna go to trial without my
evidence. We'll set a motion to dismiss. That'll be May 23rd at 9:00. Okay.
I file all the paperwork.
Very good. You step up and sign a notice.
Well,
if you got a notice, they're going to have you sign a notice, Mr. McCoy.
And here comes the legal reality check. The judge is explaining jurisdiction and separation of powers in real time. Courts can't order random private stores to preserve or hand over footage unless proper legal procedures are followed. And judges definitely cannot command law enforcement to investigate on a defendant's behalf. That's not bias, that's constitutional structure. This is the moment the sovereign shortcut theory collides with actual courtroom mechanics.
Mr. Myers is here in case number 22-4842 and 22-4840. He's set for a Nelson hearing.
All right, if you'll swear Mr. Myers in.
You're about to truth.
Yes, ma'am.
All right, sir, you're asking to have your attorney replaced, is that correct?
Yes, sir.
You wish to proceed with that motion?
Yes, sir.
You may go ahead.
I, defendant George Myers, pursuant to Blanding versus State, moves this honorable court to discharge counsel Kristen Piazza due to counsel's incompetence and ineffectiveness from current representation. In support thereof, defendant states that 1, this is an unequivocal request to discharge counsel. 2, that counsel is incompetent. And 3, that counsel's deficient performance arises from her current representation and not from past indiscretions, and is as follows. Counsel is incompetent and not adequate assistance of counsel guaranteed by the 6th Amendment. Counsel's continued representation would be ineffective assistance of counsel and will result in misjustice and an unfair trial.
Now we shift to Myers, and this is a completely different flavor of courtroom drama. He cites case law, constitutional amendments, double jeopardy. It sounds powerful. But here, the key: attorneys are ethically barred from filing motions that lack merit. That's not betrayal, that's professional duty. So when the judge denies the request to fire counsel, he's reinforcing a core rule: strategy decisions belong to counsel, not the client.
Counsel communicates with defendant at a bare minimum, does not keep defendant reasonably informed about status of prosecution. The defendant has only had one attorney visit where his co-counsel is present and has had no current communication with her and would like a second non-biased opinion. The defendant believes counsel is biased towards his charges and does not have defendant's best interest in mind. Counsel waived defendant's right to a speedy trial without defendant's consent or even discussing reasoning with him. Defendant does not believe that his lead counsel meets the requirements set forth in Florida Criminal Rule Procedure 3.112, the minimum standards for attorneys in capital cases, specifically 3.112F, lead trial counsel, and 3.112J, limitation on caseloads. Also, counsel does not abide by a client's decisions by refusing to file a double jeopardy motion after defendant showed grounds and reasoning for motion. Also, counsel had previously agreed to file a motion and now claims that she'll get in trouble for writing a meritless motion. Therefore, she lied to the defendant.
And this is the gravity drop. First-degree murder, life imprisonment at minimum. When a judge methodically confirms you understand the consequences of self-representation, that's not theatrics, that's a constitutional safeguard. Once he finds you competent, you're held to the same standard as a trained attorney. No extensions for inexperience. So here's the final question. Is self-representation empowerment, or is it walking into a legal battlefield without armor?
Counsel failed to show due diligence by not researching double jeopardy violation and a complete lack of willingness to do so. In order to better understand defendant's claim, the defendant would move this court to take judicial notice of the following relevant case law. Carlson versus State, which is 405 SO2D 173. Chictus versus Shands, which is 373 SO2D 904. Witcher versus State, 737 SO2D 584. Brown versus Ohio, 432 US 161. Harris versus Oklahoma, 433 US 682.
Is that it?
No, sir. And as in the above cases, the defendant has already been adjudicated guilty in cases 22-CF-1576 and 22-CF-1599, and is now being prosecuted again for the exact same offenses and also for greater offenses that necessarily include the lesser offenses for which the defendant has already been convicted of. The defendant has additional oral arguments to support his claims and will also move this court to allow rebuttal arguments to counsel's response to his claims, since the burden to replace and discharge counsel lies with the defendant.
Anything else?
Yes, sir.
Ms. Piazza's response.
Yes, Judge. I believe the main issue that merits response is Mr. Myers. I think his main issue is the lack of the motion that he wants filed for the double jeopardy claim, and so I think that comes down to two issues: what he's saying is the lack of research, and then the lack of filing the motion. He's provided me pages and pages of case law. I've looked at all of those. So I have diligently researched that issue. And I've also had in our office, we have somebody who does research for us, kind of like a paralegal who does research. And he's done extensive research on this issue as well, which I've discussed with Mr. Myers. He just doesn't like the decision that I've come to based on all of the research. And it was never my intent to promise him to file any kind of motion. It was more of an intent to, I will absolutely look into this. If there is a motion, I will absolutely file it. And that's still my stance, that if I ever do see a motion in this case, I will absolutely file it. But at this point, I don't see it, and I can't file a motion that has no merit because that would not be the correct way to move forward with the case. And that is why I have not. So I'm not sure if there's any other issues that you would like me to address.
I'm going to deny the motion. It's up to Ms. Piazza whether to file the motion that you're asking her to file. It's also up to her whether to waive speedy trial or not. So I'm going to deny your motion. We need another court date. Where we at? We ready to set
myself then, sir?
Is he already under oath? Pardon? He just made an argument, didn't he? All right, if you'll swear him in.
You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
All right, Mr. Myers, state your name.
George William Myers.
Mr. Myers, you've asked to represent yourself. Is that correct?
Yes, sir.
You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law. They're trained on what motions to file and what motions not to file. Do you understand that?
Yes, sir.
They're there to prepare you to prepare the case for any pretrial motions and also prepare the case for ultimately a trial. But just answer my questions.
Yes, sir.
Do you understand that?
Yes, sir.
You're charged with first-degree murder, which is punishable up to the death penalty, if all possible. But at least the minimum on a first-degree murder is life in prison. You understand that? Yes or no?
Yes, sir.
You understand if you're convicted of first-degree murder, that the least sentence you could get would be the remainder of your life in prison. You understand?
Yes, sir.
And you understand if you do represent yourself, you'll be held in the same standard that an attorney is held in. You understand that?
Yes, sir.
are you under the influence of any drugs or alcohol today which would impair your ability to make this decision?
No, sir.
Are you ever been diagnosed with any mental illness that would prevent you from making a decision in this matter? You understand, if I find you competent to represent yourself at any point in time, you can ask an attorney to be appointed to represent you.
Yes, sir.
All right. All right, I am going to find that Mr. Myers is competent to represent himself. I'm going to allow him to represent himself. I'm going to allow the public defender's office to be backup counsel. That does not mean that Ms. Piazza is obligated to give you any advice or to help you in any way until she's appointed to represent, unless she's appointed to represent you again. You understand?
Yes, sir.
All right.
Yes.
All right.
He did already have a court date. He had 2 court dates, but those were both based on my representation and that I'm going to be out for a little while. So I don't know if those will change now that he's.
We'll leave it set for a jury trial July 7th and trial management May 23rd.